ಈ ಕಳ್ಸಿನಲ್ಲ ಅದು ಕರೆಕ್ಟ್. ಹಾಕ್ಬಿಡು. ಓಕೆ, ಗುಡ್ ಮಾರ್ನಿಂಗ್ ಆಲ್. ಇದು ವಾಲ್ಯೂಮ್ ಅಲ್ಲಿ ಓಕೆ ತಾನೆ? So what is the last question or topic that we are discussing? Okay, correct. UCC. Then under historical underpinnings, the only major thing left out. Okay, I'll show you the PYQ, then you'll get a better idea. Done. Good. Yeah, so this is another question related to historical underpinnings, the first topic. This one we need not discuss because you know the very basic question, as I keep telling, every year at least one, sometimes two questions will be from your basics. Very basics like financial emergency or 1 year joint session that we'll discuss under your parliament. So like that, nothing analytical. So these very simple kind of questions, so just go through it. Pattern, it's not a pattern, it's not a theme. Chance of getting repeated is very, very less. But just if you want, note it down. Just to keep it in mind that okay, they can ask something like basic related question also. Only for that purpose you have to keep it in mind. Then if you want, obviously just try to recall the points. You need not write this because there is nothing to be written here. So look at the first subheading, subpart, second subpart. Typical direct. Lakshmikant 1, under what circumstances financial emergency be proclaimed by the president? Obviously we all know the moment you get that, what article 360, president can proclaim financial emergency when there is a threat to the financial stability or credit to the entire country or part of it. So but again what they have not done, the term called as financial threat to the financial stability or credit, they have not defined. Broadly you can assume it to be something called as BOP crisis or huge inflations or something like that, but we don't know exactly what does that mean. Then obviously you have to write certain, what do you call this, sir, they have not talked about approval, all those things, it doesn't matter, you have to write about that. How is it approved? Remember all those things, very, very basics. It has to be approved by simple majority by both the houses within 2 months. Once approved, what you don't have here, there is no concept of reapproval within 6 months. Once approved, it will continue until revoked by the president. Recall, so there is parliament has no power to revoke all those things directly, a president can only revoke. And recall your impact of financial emergency, very, very simple, direct. What will happen? Exactly. So government of India can give directions, orders, whatever you call it as, to any state with respect to the fiscal discipline, financial discipline. President can tell the governors to reserve what? Anything related to money bills, financial bills to his assent. President can reduce the salaries of, exactly, officers of union government, state government, including Supreme Court and High Court judges. So broadly these are your consequences, very, very direct, and obviously we know, so that what in Indian context, not a single time financial emergency has been imposed, so there is no need to even write this. So national emergency related mains questions are very, very less chance. We have put it, if you can recall, just to go through it, but I don't think this is a probable question, because remember, I think there are some criticisms going on, if you have heard, means that government wants to call a special session to discuss internal emergency. Indira Gandhi's 2024 marks the 50th year since the imposition of internal emergency, but asking a question on that, they'll not ask you like a maybe post-independence kind of a question they can ask, but if they can't ask you like what are the critical, because it's a very controversial topic, maybe what they can do, like how they have asked these basics, what they can do, National emergency related basics they can ask. Under what circumstances national emergency is imposed under Article 352? What are the different types? What are the consequences? At least their consequences a little detailed. Recall that. Impact on center-state relation, impact on fundamental rights, impact on the life of Lok Sabha and State Assembly. That's a little detailed. Under center-state relation, you have legislative impact, executive impact, financial impact, so that you can stretch a little. Understood? Just if in case for a basic question, because you have written it, in this context, write that. This is a kind of question. You don't have to write the answer because you understood the question, right? Only because they are telling last year it was like how many years? 50 years of emergency. Write the question. Context. In the context of 50 years of imposition of national emergency in 1975, in the context of 50 years of imposition of emergency in 1975, and make that typical theoretical question. Context of 50 years of the imposition of national emergency in 1975, discuss the constitutional provisions related to emergency, related to it. Discuss the constitutional provisions related to it. Discuss the constitutional provisions related to it and the impact of emergency on different aspects of the constitution, and the impact of emergency on different provisions of constitution, different aspects of constitution. Impact of national emergency on different aspects of constitution. That's a typical Lakshmikant one. We don't have to write an answer or anything for that. On this pattern, we are just extrapolating. Fine. And then let's look at the next question, because this one again is not a pattern, but for you to go through it, just go through the question, because probably that year I think there was some kind of a honor crime or something which had happened. Not a single time it has been, this is the only time. Khap Panchayats in use for functioning as extra constitutional authorities, delivering pronouncements amounting to human rights violation. Discuss whatever legislative, executive, judicial actions taken to set the things right in this regard. Recall that Khap Panchayats means what? Just to brief. Exactly. So related to those what you call as the caste-based panchayats, mostly prevalent in states like Haryana, parts of Rajasthan, parts of Uttar Pradesh, and all those things. Obviously, remember that concept of Gotra, they take it very, very seriously. It's a traditional institution. It has no constitutional legal basis. So people have, for a long time, even in South India, in Tamil Nadu, they call it as Kata Panchayat. In West Bengal, they call it as kangaroo courts. Bengali name is there, but they are famously called as kangaroo courts. Kangaroo courts means they don't follow your typical what? Rule by law, rule of law and all those things. Directly they'll listen to it and then and there itself they'll settle the matter. So that's why they are called as kangaroo courts. They don't follow a typical detailed procedure like any other courts. Obviously, why is it controversial if you have heard? Very basic controversial thing is what? First point, as I told, they don't have constitutional legal basis. And two, mostly it is dominated by the upper caste, or you can say the dominant caste, and of course the men and the elders. That means obviously, so the women angle, the patriarchy angle is very, very, strong and criticized. One of the reason, not the only reason, that Khap Panchayats is responsible or criticized that it has been involved in a lot of these honor crimes. They have encouraged these honor crimes. Honor crimes means, understand, right? In the name of caste or in the name of the pride of either the girl's family or all those things. So the killings will happen. So that is the context. So based on that, obviously, multiple times Supreme Court has already criticized them as what? Supreme Court has told that honor crime is one of what? Is one of the rarest of rare crimes. Recall, the moment you tell one of the rarest of rare crime, what is it eligible for then? Death penalty. That's what Supreme Court has told. That Supreme Court has clearly told that they are unconstitutional. They don't have any legal existence. But in practice, it keeps continuing. So in fact, Supreme Court also told, Law Commission also told that you should pass a separate law to deal with this Khap Panchayats aspect. But Parliament has still not passed. In fact, probably Law Commission had drafted a bill also, but that act has not been passed. So then how do you deal with it? Of course, they'll deal these kind of crimes through what? Several provisions of your IPC, CPC, SC/ST Atrocities Act, Protection of Civil Rights Act. Under those aspects, they'll deal with it. We don't have any specific act for that. Few state governments have come up with guidelines, but no act. That's why there is a legislative loophole here. Other aspects we'll tackle. If you want, we'll write this question. I'm again repeating, this is not a theme. Because a lot of students, because I think in the last 3-4 years, Khap Panchayat topic is not under huge discussion. So a lot of you might not be aware about it. Only for that aspect we'll mention. Please note the question. Maybe in your essay, maybe in your ethics somewhere you can make use of these points. That's it. Kind of broadly you can link it to panchayats, maybe fundamental rights aspect only. Current affairs actually. Fine. So these are the keywords, all the keywords you need to address. So you, as I keep telling, please don't only focus on one particular keyword and keep on writing about it. Yeah, please write first. Let's write about Khap Panchayats. Introduction, you have to write about that. Address it first. Khap Panchayats are traditional. Khap Panchayats are traditional caste-based panchayats. Traditional caste-based panchayats which are predominant in caste-based panchayats which are predominant in North Indian states like predominant in the North Indian states like Haryana, Western UP, Rajasthan, etc. North Indian states like Haryana, Punjab, Western UP, etc. Rajasthan also to an extent. They are also known as Khap Panchayats in Tamil Nadu. They are also known as Khap Panchayats in South India also you can say, or Tamil Nadu. Khap Panchayats in Tamil Nadu. Fine. Yeah, now set the context. It has been controversial. It has been controversial because of its, or they have been controversial because of where it has been controversial because of its, because we use the same word, pronouncement, means kind of orders they give. Controversial because of its pronouncements which has violated human rights. Pronouncements which have violated human rights. Which have violated human rights. Yeah, now, for example, or for instance, they have declared illegal. They have declared illegal many Sagotra marriages because they take the concept of Gotra very seriously. They have declared illegal many Sagotra, same Gotra marriages. They have declared illegal many Sagotra marriages. B. They are alleged to have. They are alleged to have. They have been alleged to have. They are alleged to have encouraged honor crimes in multiple instances. Alleged to have encouraged honor crimes in multiple instances. honor crimes in multiple instances. So that first part you are addressing. Now obviously what? Put a broad, broad subheading, first criticize them. You can say criticism of Khap Panchayats. So that is human rights violation angle you address, then write the overall criticism. Criticism of Khap Panchayats. Obviously, you know, broader points. First major point is what? Supreme Court has declared them as unconstitutional. Supreme Court has declared them as unconstitutional. Fine. 2. Next one. They are mostly dominated by upper caste men and elders. Mostly dominated by upper caste men and elders. Upper caste men and elders. Then they go against the rights of women, or they have violated. They exist because, as I told, one is traditional angle, and two, they resolve a lot of these land disputes, marriage dispute, property disputes, all of them. They go against the rights of women and lower castes. Against the rights of women and lower castes. Then they are a threat to the existence of panchayats. They pose a threat to the existence of panchayats. Because when they exist, how are you existing then? Then they are criticized as kangaroo courts. So kangaroo courts means what? No procedure, nothing they follow, directly they will give you order, punishment, whatever. They are criticized as kangaroo courts as they do not follow any procedures. They don't follow any procedures or natural justice, principles of natural justice. As they don't follow any procedure or principles of natural justice. So these are various ways. I mean, why are we criticizing them? So then comes your broader measure, you can say, or you can mention it that itself. Actions taken by the critically analyzed. Okay. Below that you mention measures taken to address the challenges of Khap Panchayats. Measures taken to address the challenges of Khap Panchayats. Under that, legislative. Because they are using the terms legislative, we are just sticking to that. Legislative measures. First point you clarify what? There is no one specific act. There is no one specific act to deal with Khap Panchayats. No specific act to deal with Khap Panchayats. No specific act to deal with Khap Panchayats. Then how are they tackled? Exactly, it is tackled through various provisions of IPC, now what you call as BNS. It is addressed through various provisions of IPC or BNS, SC/ST Atrocities Act, Protection of Civil Rights Act. Various provisions of IPC or BNS, SC/ST Atrocities Act, Prevention of Atrocities Act. Or what is the next one? Protection of Civil Rights Act. And who has told that it has to be? Exactly, both Supreme Court and Law Commission have recommended that a specific act should be passed. In fact, Law Commission had drafted a bill also. Now, these are all very old topics. I don't remember the exact name of the bill, and it doesn't matter much. Only for the structuring part we are writing this. Both Supreme Court and Law Commission had recommended that there should be a specific act to deal with it. And then judicial measures. One we have already told about. Judicial measures. Supreme Court has declared that honor crime falls under which one? rarest of rare crime, hence you know the punishment, right? Supreme Court has declared that honor crimes fall under rarest of rare crime, hence eligible for death penalty. Honor crimes fall under rarest of rare crime, hence eligible for death penalty. Hence eligible for death penalty. And what they also told, Supreme Court also said that there is no honor in this crime. So it is actually, they told it is dishonor crimes. Supreme Court said that there is no honor in such crimes. Then few executive measures, if you want, executive measures. Few state governments have given or have issued certain orders. Means that's what Punjab, Haryana, few states have issued orders to deal with Khap Panchayats. Orders to deal with Khap Panchayats. And obviously what they have to do? Police should take such crimes more seriously, because they are telling critically analyze, specific measures are less. Police should deal with such crimes with zero tolerance, you can say. Police should deal with such crimes with zero tolerance strategy, zero tolerance approach. Should deal with such crimes in zero tolerance approach. Yeah, so those are broadly the points. Then broader sum up, you can say Khap Panchayats exist. Khap Panchayats exist because of their ancient roots, ancient legacy, exists because of their ancient roots. What people have to do? People have to reject them, because Supreme Court has clearly told, so that's why you can take that stand. People have to reject them as democratically elected panchayats, as democratically elected panchayats function at the grassroots level under 73rd Amendment. Democratically elected panchayats function at the grassroots level under 73rd Amendment 1992, based on 73rd Amendment 1992. Right? This is how you could have structured it. As I told, it's not a theme, we don't discuss it very regularly. Only to know based on the keywords, how do you have to play with the points. Now, this is a theme. Look at it, almost this we have done. Almost you can say 3 questions. Another question is there that I will show it under. Look at this question. Read it broadly, you will understand the core theme. Parliament's power to amend constitution is a limited power, cannot be enlarged into absolute power. Explain whether Parliament under 368 can destroy basic structure by expanding its amending power. Means broadly about amending power, constitutional amendment, basic structure. Again another one. Yeah, okay, let's read this first. Supreme Court keeps a check on the arbitrary power of Parliament in amending the constitution. Again, that means the broader aspect of constitutional amendment, basic structure, like that. Kind of related to it. Constitutional morality is rooted in the constitution itself, founded on its essential facets. Explain the doctrine, relevant judicial decisions. I'm sure there is another one also that I think is under judiciary, PVQs. Anyhow, we'll discuss later also. 2013, I think this is the same question. Supreme Court check on the arbitrary power. Okay, they've put it here. Correct. So these are the broadly 2 or 3 questions related to 2 important, very, very important topics. One is basic structure, another one is constitutional morality. From mains perspective, it is very, very important. Even though they don't ask a direct question on basic structure, obviously what you have to do in your parliament chapter or in your judiciary, imagine how many times you may have to refer to basic structure doctrine or Keshavananda Bharati case, its importance, whatever, so many things. That 100% we need to write first them about the content part, then automatically you can write one answer about it. First put the broader heading. Amendment of Constitution. Amendment of Constitution. That remember Article 368, so what do you call those things will not write. Amendment of Constitution. Just remember the first basics, what you need to remember. Part 20, Article 368. Part 20, Article 368. Fine, if you want, because you never know, sometimes you may have to write exactly Article 368. So for 368 you write Article 368. Parliament can amend any provision of the Constitution. Parliament can amend any provision of the Constitution using its constituent power. Actually, they tell Parliament may exercise its constituent power. Parliament can amend any provision of the Constitution using its constituent power either by, what are the three words? Addition or variation or repeal. Using its constituent power either by addition or variation or repeal according to the procedure mentioned under 368, or according to the procedure mentioned. According to the procedure mentioned. So I am making you write this statement because if the question is an amendment of Constitution, you have to reproduce the same, so what do you call this, sentence or provision or whatever. It matters a lot. Fine. Then the that procedure that all is very basic. Remember that you can introduce it either in Lok Sabha or Rajya Sabha, either by minister or private member, no need of prior recommendation, special majority, no joint sitting. 24th Amendment, it is mandatory for President to give the, that all you know. Even if they ask such kind of question that what is the procedure to pass a bill under 368, I think that you will easily handle. I don't have to discuss that because that's typically your prelims part. Fine. Again, just to mention, put this broader heading as what? Types of amendment. Again, we'll just mention it in 2-3 provision. Very basics, we already have discussed it. I mean, you have already multiple times studied for your prelims. We will not focus those prelims aspects very high. I mean, that will not be priority for us. Types of constitutional amendment, make 2 column. Under other articles of Constitution, just make simple column. On one side you write under other articles of the Constitution, and below that simple majority. Under other articles of Constitution, simple majority. Again your basics only, Lakshmikant basic prelims. Other articles of Constitution, simple majority. Obviously which provisions? Exactly, acts related to or provisions related to Article 2, Article 3, provisions related to Article 2, Article 3, 169, what is 169? Yeah, creation or abolition of councils, 169. Fine. Obviously other one is what? Which one? Second schedule, second, fifth, sixth schedule, second, fifth, sixth schedule, election, citizenship, second, fifth, sixth schedule, elections, citizenship, etc. Broader ones, that's it. Because here they don't ask you like prelims like which among the following is, that kind of questions you don't get. Just when if in case you have to write, just keep it in mind. Under 368, other column. Under Article 368, you know that obviously just mention it few. Again, no need to mention all the provision. Under Article 368, under that A, special majority, that also you all know, very basics, fundamental rights, DPSP, fundamental duty, etc. Fundamental rights, fundamental duties, DPSP, etc. And then special majority with ratification, that also you know 2-3 points you mention. Special majority with ratification of 50% states. Example which one? Obviously, yeah, election of president, legislative powers, that you have it, you had a prelims question also right this time, 7th schedule, etc. Yeah, this is your very basics. Now for us concern is what? Even that is constitutional amendment a law under Article 3 and under Article 13 or not, in which finally in Keshavananda Bharati case it clarified, that also is your very basics. Our concern, put the heading basic structure doctrine. Basic structure doctrine. So this is the very important topic for us. Keshavananda Bharati case, 13 judge bench. Keshwananda Bharati case, 13 judge bench. 13 judge bench. Fine. Yeah. So obviously, what is it? It was related to Kerala Land Reforms Act 1967. Kerala Land Reforms Act 1967. 24th Amendment, 25th Amendment 1971. 24th, 25th Amendment 1971 and 29th Amendment. I think few provisions of 27th also, 29th Amendment. Then in a 7-6 verdict, Supreme Court upheld, or Supreme Court favored the government, that's it. In a 7-6 verdict, Supreme Court favored the government, means largely the judgment was in favor of government. Supreme Court favored the government. Fine, and obviously what they introduced? Exactly right, that basic structure doctrine was introduced. Basic structure doctrine was introduced. And write the broader definition. Basic structure doctrine was introduced, and below that it refers to the core values and principles, or you can say core provisions. It refers to the core provisions and principles of the Constitution. Core provisions and principles of the Constitution which cannot be altered by the Parliament or anybody for that matter. Core provisions and principles of the Constitution which cannot be altered by the legislature or executive for that matter, which cannot be altered by the legislature or executive. Then obviously what? Supreme Court determines the provisions of basic structure. Supreme Court determines the provisions of basic structure, and what is it? It is a dynamic list, evolving list. Supreme Court determines the provisions of basic structure. It is a dynamic list. And then few provisions you mentioned that. It is a dynamic list which includes, write 4, 5, whatever you know that, please write. Parliamentary system, federalism, secularism, rule of law, separation of power. This is the typical answer we are writing. I mean, if you know this content, automatically you can write the answer. Parliamentary system, federalism, secularism, rule of law, separation of power, balance between FR and DPSP, etc. Free and fair election, judicial review, independence of judiciary, so many are there. Anyhow you would have beheaded obviously a lot of them for your prelims also. Till here normally we study in prelims also. Now significance of the doctrine. Significance of the doctrine. Significance of the doctrine. First one, it upholds the principle of constitutionalism. It upholds principle of constitutionalism, in bracket limited powers. Upholds the principle of constitutionalism, that is limited powers. Limited powers. Fine. How do you say that? For instance, limited power of Parliament itself is basic structure under Minerva Mills case. So many cases, including Minerva Mills case. For instance, limited power of Parliament itself is part of basic structure, in bracket Indira Gandhi case also you can say, Minerva Mills case also you can say. Limited power of Parliament itself is part of basic structure, Indira Gandhi case or Minerva Mills case. That is one, upholds the principle of constitutionalism. Fine. Then B, it has helped Supreme Court. It has helped Supreme Court to perform its role as. It has helped Supreme Court to perform its role as what? Guardian of Constitution and guarantor of fundamental rights. It has helped Supreme Court to function or to perform its role as guardian of the Constitution and guarantor of fundamental rights. Guarantor of fundamental rights. Then it has it has protected the democratic values. It has protected the democratic values by preventing concentration of power and arbitrary power. It has protected the democratic values, ideals, by preventing concentration of power and arbitrary power in any individual or organ, institution. Preventing concentration of power and arbitrary power in any individual or institution. Keep underlining the keywords, in any individual or institution. Any individual or institution. Then Justice Chandrachud has famously described it as what? North Star of Indian Constitution, guiding light. Justice Chandrachud has famously described it as North Star of Indian Constitution. North Star of Indian Constitution. Again, keep underlining the keywords. Chandrachud is a keyword, North Star is a keyword. Make it as an habit if in case you still don't have that. North Star of the Indian Constitution. North Star of Indian Constitution. Fine. Then next one. What is it famous? There is other one. Okay, that's okay. Fine. Indian. Yeah. Another aspect you can say. It is an inspiration for multiple developing countries like. It is an inspiration for multiple developing countries like Bangladesh, Malaysia, and few African countries, means South Africa, Ethiopia, like that. It is an inspiration to multiple developing countries, many developing countries like Bangladesh, Malaysia, and few African countries. And few African countries. And few African countries. Fine. So then next one is what? Criticism. Criticism of the doctrine. First one, it has no constitutional basis. It has no constitutional basis. Means even in Constitution or in Constituent Assembly debates, there is no mention about it. It has no constitutional basis. No constitutional basis. Fine. Then B. It is criticized that judiciary has used it for its own benefit. Criticized that judiciary has misused it also, you can say. Judiciary has misused it for its own benefit. Judiciary has misused it for its own benefit. Simple example is what? The landmark exactly. Example, 99th Amendment 2014, NJSE Act 2014 declared unconstitutional by Supreme Court for violating independence of judiciary. 99th Amendment 2014, NJSE Act 2014 declared unconstitutional for violating independence of judiciary. For violating independence of judiciary. Violating independence of judiciary. Fine. Then the doctrine is subjective in nature. Means what? Ultimately depends on whom? Interpretation of judges. The doctrine is subjective in nature. That is, depends on the interpretation of the judges. Doctrine is subjective in nature, depends on the interpretation of judges. Depends on the interpretation of judges. Then next one, in a democracy, people, thereby representatives are supreme. People, thereby representatives are supreme. People and thereby representatives are supreme. And what this doctrine does? Exactly. This doctrine limits the power of legislature or parliament. It limits the power of legislature. Basic structure doctrine limits the power of legislature. Then it has contributed to judicial supremacy thereby compromising the balance of power, contributed to judicial supremacy, thereby compromising the balance of power, thereby compromising the balance of power, compromising the balance of power. So like that, various criticisms that you can keep on writing. Then of course, final conclusion, broader conclusion you write. Despite few criticisms, despite few criticisms, despite few criticisms, the doctrine is considered to be, basic structure doctrine is considered to be, despite few criticisms, basic structure doctrine is considered to be the most important judicial innovation, the most significant judicial innovation in the post-independence history. It is considered as the most significant judicial innovation in 21st century, or you can say not 21st, post-independence history, in post-independent history. And what they tell it as? It has saved Indian democracy forever. It has saved Indian democracy forever. Saved Indian democracy forever. Fine. That's a very, very famous question on basic structure. Anytime when there is a question on basic structure, same pointers, depending on the demand of the question, you have to change a little bit here and there. You have to play with the same points. The other one or two, of course, if you search, you will get it. You can keep adding, but the core is this only. Now, exactly same. Copy this question first. A lot of points will overlap, so I'll just tell the broader structure and we'll discuss the judicial decisions. Copy the question first. They are telling it is rooted in the constitution itself. Explain the doctrine, relevant judicial decisions. Yeah. So if you look at the keywords, what they're trying to say is obviously the first keyword. They're telling rooted in the constitution and founded on its essential facets. These points to a little extent, as I keep telling in the beginning, you need to talk about that. Then explain the doctrine, means what are the broader provisions of all of that, and then most importantly, what you need to do, substantiate with relevant judicial decisions. First define that. Directly the same exact definition you can use whenever you have constitutional morality. According to Ambedkar, constitutional morality refers to, according to Ambedkar, constitutional morality refers to adherence to the constitutional morality refers to adherence to the core value. That means it is in spirit. In reality, to what extent we follow. Adherence to the core values and principles of constitution by adherence to the core values and principles of the constitution by every individual as well as people in power or every organ, by every individual and organ, every individual and organ. Fine. Then below that, now you can say there was a reference to it in the Constituent Assembly debates. There is a reference to it in the Constituent Assembly debates. reference to it in the Constituent Assembly debates, though the term is nowhere mentioned in the Constitution. There is a reference to it in the Constituent Assembly debates, though the term is not mentioned in Constitution. Though the term is not mentioned in Constitution. Right? Then it is a dynamic list, or it means provisions if you want to say. It is a, or it consists of, it is a dynamic list only better. It is a dynamic list which broadly consists of, bring those exact word, which broadly consists of the essential facets of the Constitution, which is broadly based on essential facets of Constitution. Which is broadly based on the essential facets, that is features of Constitution. Essential facets of Constitution, and then right, what all does it include? Maybe you can make it as a, what do you call this, tabular, I mean mind map kind of a one also, and you can write, or you can mention it as a list, that's left to you. Fine, what all does it include then? Exactly, values in preamble like, write them, equality, liberty, justice, fraternity. Values in the preamble like equality, liberty, justice, fraternity. Then dignity of an individual, then secularism, SOP, ROL, separation of power, rule of law, etc. Separation of power, rule of law, etc. Yeah, then for your clarity, write that, because now my students have keep getting confused within basic structure and constitutional morality. Basic structure is a broader concept. Basic structure is a broader concept and talks about the features, means provisions. Constitutional morality focuses on practical. Constitutional morality focus on the practical application of the core values of Constitution in real life. So it is more of in day-to-day life, however, to what extent are we following, especially people in power. Practical application or practical following of the core values of Constitution in the daily life. So it's more of practical concept. Basic structure is more of theory concept, that so and so is all basic structure like that. And the core, and now obviously what? Remember always, significance of the doctrine, criticism of the doctrine largely is what? Whatever you write for basic structure, same, more or less same points you can copy paste. Fine, just one line, just sum up, because you don't have to write the again and again. Significance and criticisms of the doctrine is mostly, just replace the words, that's it. Significance and criticism is similar to that of basic structure. So next time, even if you get a question, just stick to that. But judicial cases changes. So then below mention important judicial decisions. Important judicial decisions. Of course, you don't have one landmark case like Keshavananda Bharati, but multiple cases. And that first one is what? All India Judges Association case, I mean Young Lawyers Association case. All India Young Lawyers Association case. Which is what you are famously? Yeah. And write that statement. Constitutional morality will prevail over customary morality or traditional morality. All India Young Lawyers Association case. Constitutional morality will prevail over customary or traditional morality. Customary or traditional morality. Then Navteet Singh Johar case, replace the term traditional or customary by social. Navteet Singh Johar, section 377, maybe yesterday twice we have written that. Replace the term by social morality. Customary morality will prevail over social morality. Then NCT Delhi versus Union of India case. NCT Delhi versus Union of India. NCT Delhi versus Union of India. CM and LG of Delhi. CM and LG of Delhi should abide by constitutional morality. Should abide by the constitutional morality rather than fighting for their one-upmanship, means rather than fighting for their powers, superiority. CM and LG of Delhi should abide by constitutional morality rather than fighting for their superiority. Fighting for the superiority. Then if you want current affairs angle, the recent, which one? In the recent Tamil Nadu governor case, rather than fighting for their superiority, in the recent Tamil Nadu governor case, Supreme Court criticized that. Recent Tamil Nadu governor case, Supreme Court criticized that. Supreme Court criticized that the governor has violated constitutional morality. Criticized that the governor has violated constitutional morality. Constitutional morality. Fine. And then bring those broader conclusion. For this, a little change of, conclusion you can change a little bit. You can end with again Ambedkar's statement. Ambedkar had said that we can have the best constitution in the world. Ambedkar had said that we can have the best constitution in the world based on its features. We can have the best constitution in the world based on its features. However, its success depends on the character and integrity of the people who run it. However, its success depends on the character and integrity of the people who run it. Character and integrity of the people who run it. See, we have not brought the word constitutional morality. You have to bring those words. That's why what you do. Hence, the ultimate success of constitution. Hence, the ultimate success of constitution depends on constitutional morality of the people in power. Ultimate success of the constitution depends on the constitutional morality or adherence to the constitutional morality by people in power. Constitutional morality of the people in power. As I keep telling, whatever the question is based, that particular keyword should get repeated throughout your question, throughout your answer, especially in your intro, those keywords should reflect. In your conclusion, those keywords should reflect. You have to bring it back. Or else evaluator feel that you have written some vague conclusion, something, whatever came to your mind, you have written it. So you have to bring those words, whatever is there. Right? And now what you can do is, because we have discussed about both, so please note down this question. Both more or less mean the same question. First, write down both the questions, and I'll tell you which one you can write. Copy the questions. So So whatever we have written, more or less same points only, but you should write it in time frame now. Fine, this is one question. Note down the questions first. Then the other question. So core demand, if you observed, both is same. There they have made it a little broad and then they have linked to the words like Article 368, basic structure and everything. But you should write the answer for that previous question. Just note it down. Quick. And now, what you do for this particular question, anyhow you have written down the question. I think that as it as a 10 marker, you write it as a 10 marker itself. I'll keep it as okay, we'll keep it as 8 itself. Please write that whatever earlier question, but remember the Article 368 basic structure, that question, write it as a 10 marker, 2 sides, 8 minutes. So identify the keywords, all of them, identify the subparts and structure it accordingly. Whatever broader points, whatever we discuss, no, same points only. But you need to structure them. Okay, so if you look at it, so what they are trying to ask is that Parliament's power, whatever it is there to amend the constitution, is very limited only. So do you think Parliament under 368 can expand its power unlimitedly, means absolutely, thereby destroying the basic structure also, is what they are asking. Of course, what do you call this? The point you know that no, you cannot expand it, thereby destroying basic structure, that concept is not allowed. That stand is fine, but you can't just write that stand, right? You have to use that argumentation points. How do you do all those things? Fine. So obviously, how the different ways of starting, because the question at the core is about what? Amendments. Parliament's power to amend the constitution is the core topic of the question. So in the introduction, better way, there are multiple ways, better way is what? Talk about Article 368. Recall, that's why we made you write that Article 368 exact word, that itself you can write. That Article 368 empowers Parliament to amend, that aspect you can start with. Or what some people do, Article 368 empowers Parliament to amend the constitution, only that they'll write, that's also is fine. So, but better is you would have mentioned about that. Then if you want one para, you can write what? That in the post-independence constitution has amended, Parliament has amended constitution 106 times, and significantly so and so, whatever first for, what do you call this, 42nd, 44, something like that also you can mention. If you want one or two lines about that. Then what you need to come to, that obviously what? Parliament's power to amend the constitution is a limited power. And then you need to talk about that. How is it a limited power? Why are you telling that it is limited power? All those things you need to talk about that. So it's saying that what? That Supreme Court itself has declared it as what? Limited power of Parliament as basic structure in your Minerva Mills case, Indira Gandhi case, Indira Gandhi versus Rajnarayan case. And why limited power is required? Because it is based on the principle of constitutionalism. It will prevent concentration of power in one particular organ. And remember, argumentations you can use. If you want, you can rewrite the answer, but I think points will get repeated. So because remember, India doesn't follow the principle of parliamentary supremacy or parliamentary sovereignty. What we follow? We follow constitutional supremacy. So all those argumentations we need to bring. Supreme Constitution itself is based on what? Separation of power, Article 50, independence of judiciary is there, judicial review is there. So obviously, Constitution itself is putting a check on that. Then refer to the basic structure aspects also. That Parliament, no way what they can do, amend or destroy, which one? Basic structure. Why is it like that? Why? Because basic structure is not mentioned in the Constitution. Who has invented or innovated that? Judiciary has innovated it. And who has the power to control? What do you mean by basic structure and everything? Judiciary has the power to control that. And remember, Supreme Court is what? Guardian of the Constitution. Supreme Court is ultimate interpreter of the Constitution. And Parliament can no way destroy the basic structure. All these arguments you need to bring and try to say. And then of course here and there, as I told, like how Chandrachud described as North Star, or it is considered as the most important judicial innovation, you cannot alter it at any cost. If you want, if you have space, yes, there are some criticisms, you can't write another paragraph. There are few criticisms of basic structure, agreed, that it has no constitutional basis and it has been misused. However, what you should always tell, the doctrine is very helpful, and you have to refer to that again, that limited power of Parliament is, what you can say, is better or is much essential for the larger health of the democracy. It prevents arbitrary power. It prevents concentration of power. All those keywords should keep coming back. The core arguments in and around whatever we have discussed, in and around that only it will be there. The way you structure it and the way you address all the keywords of the question is the key. If you don't address all the keywords, you only keep writing about basic structure or Article 368, that means you will miss out on that 5 out of 10. Clear? There is no new points here, whatever points you had already written. Structuring and the way you address the keywords of, all the keywords of the question is a challenge. Is it clear? Okay, so you would have understood, the more and more you write, you will understand that limitations. Maybe you might be able to fill the space, maybe your handwriting would have, would not be up to the mark. Or maybe you would have felt that you are not able to get the points itself, that I know the demand but I am not able to generate arguments. Or maybe you will feel that, okay, I have points but these are all very, very general points, keywords are not there. Or you would have addressed only one keyword, you would miss out on all the multiple keywords that's there in the question. So different challenges will be there, recognize those challenges first. So if you are not able to write generate arguments properly. As I told multiple times yesterday also, what is the weakness means? What is your limitation? You have not revised it more. Keywords are not there in your subconscious mind. So that means you need to revise multiple times, write multiple times. Handwriting is getting affected means writing practice is missing. Every day you can keep a target, half an hour target or something. Try to only write the number of words. Sir, I am able to write, but my font size are less, I am not able to fill the space. Space management is also equally important. Increase the font size. Spacing between the lines, spacing between the words matters a lot. As I keep telling multiple times, mains is not only about content, it is largely management skill. How do you manage time? How do you manage space? Because remember, demand of the question, quality of the content, presentation, time, space. Everything matters. Sir, I am good in content, I am good in quality of arguments, but I don't have time management skill. The game doesn't work for you. Everything is fine, but space management I am not able to do. I will only finish off in 1.5 side or 1/4 side. It doesn't work. Everything is good, but presentation is not up to the mark. Again a challenge. So all the aspects has to work. Speed, that's also the very important attribute. Fine. Please recognize those challenges. So or what you do, based on that, every question you only keep writing your limitations in the margins. That okay, I failed in this question. What was my challenge? Was the time your challenge? Was the arguments your challenge? Was the presentation challenge? Identify and note it down. Because I normally keep telling that if you are ready to fail every single day here, that means you will succeed in the exam. If you are not ready to fail here means identify your weakness and improve. That means we are postponing our failures. So better you identify limitations, don't hesitate. Face that. Because I know a lot of you might be writing the first mains or probably the next mains, whatever it is. Don't hesitate to understand your limitations. Fine? Okay, so that is broadly, correct. Yeah, fine. Correct. That's how you have to do. In the beginning, talk about Article 368, limited power, why is it important? Then talk about can the Parliament or does the Parliament have the power to destroy basic structure? Then you tell how not. And then conclude by saying there are few criticisms of basic structure, but for ultimate things it has to be backed, and limited power itself has always been the core, because based on that only democracy will survive. You can bring the way, see the beauty is what? You can refer to anything. You should have that smartness to link to this. See, for example, Sir Ganesh mentioned Golaknath. You can, but because it is not directly linked, then how do you have to link? You have to link it by saying, in Supreme Court in Golaknath said that Parliament has limited power, hence they cannot amend fundamental rights. That word of limited power you need to link. If you only say in Golaknath case that it reversed Shankari Prasad judgment, where is the link? Are you able to link to the keywords of the question is the challenge. If you don't link, ultimately nothing will work. I think you got the point. How do you link it to the demand is always a major challenge. Judicial review, yes, that's what I told. Judicial review you can write, independence of judiciary you can write, Article 50 separation of power you can write. Of course you can write. You have to, you have to write. How Constitution itself supports that. Is that fine? Or do you think even though we wrote basic structure, you feel like this is a little tricky demand means we'll write the answer again. If you feel like that. Okay, please write then. Anyhow, you would have written it, but better for you to understand the structuring better. Because it's a very little tricky question. Though you feel like, I know it sir, but I don't know how to argue, structure the arguments. Yeah, start by referring to Article 3 state. It's like rewriting, it's fine because the more and more you write, you will understand the structuring part better. Article 368 says that Parliament may in exercise of its constituent power. 368 says that Parliament may in exercise of its constituent power, keep underlining the keyword, that's also a very important skill. Parliament may, in exercise of its constituent power, amend any provision of the Constitution, either by addition or variation or repeal. Again keywords. Either by addition or variation or repeal according to the procedure mentioned. Or variation or repeal according to the procedure mentioned. According to the procedure mentioned. Below, according to the procedure mentioned. Parliament has passed 106 amendments, constitutional amendments till now. Parliament has passed 106 constitutional amendments till now. Important ones being 106 amendments till now, and or you can say the important ones are, just write some 3-4 important ones are: First Amendment 1951, 42nd 1976, 73rd, 74, 1992, and of course 106th. First Amendment 1951, 42nd Amendment 76, 73rd, 74th 1992, 106th 2023. 2023. Fine. Then Constitution itself has multiple provisions. Constitution itself has multiple provisions which limits the power of Parliament. Constitution itself has multiple provisions which limits the power of Parliament. Itself has many provisions which limits the power of Parliament. Under that mention, separation of power Article 50. Separation of power Article 50. Then independent judiciary or independence of judiciary and judicial review Article 13. Independence of judiciary and judicial review in bracket Article 13. If you want, just like, if you know that, just mention in one line. But if Parliament tries to violate fundamental rights, it will be declared unconstitutional. Ultra vires. If Parliament tries to violate fundamental rights, you know that any law or part of the law which violates a fundamental right, if Parliament tries to violate fundamental right, it will be declared unconstitutional. It will be declared unconstitutional. Then if you want, Supreme Court has declared limited power of Parliament as part of basic structure in Indira Gandhi case, Minerva Mills case. Indira Gandhi case, Minerva Mills case. Indira Gandhi case, Minerva Mills case. Fine. And then below again continue that. Now do you understand this? Parliament cannot destroy basic structure. Okay, we could have mentioned about basic structure first. Parliament cannot destroy basic structure. Put that is a subheading. Parliament cannot destroy basic structure. There first you tell what is basic structure. Basic structure is a judicial innovation. Basic structure is a judicial innovation by Supreme Court in 13-judge bench Keshwananda Bharati case. So those words like 13-judge bench, everything also will add a value. Basic structure doctrine is a judicial innovation by Supreme Court in 13-judge bench Keshwananda Bharati case 1973. Then below Article 368. Article 368 does not empower Parliament to expand its power or to expand its power into absolute power. Article 368 does not empower Parliament to expand its amending power into absolute power. Expand its amending power into absolute power. In bracket, Golaknath case. Golaknath case. Then basic structure doctrine. Basic structure doctrine upholds, in one line you can sum up that, upholds the values of constitutionalism, upholds the values of constitutionalism, separation of power, rule of law. Constitutionalism, separation of power, rule of law. Then Chandrachud, Justice Chandrachud has described it as, Justice Chandrachud has described it as part of basic structure, as North Star of Indian Constitution. Justice Chandrachud has described it as North Star of the Indian Constitution. Then ultimately who has the power? Supreme Court controls, or Supreme Court determines basic structure. Parliament has no control over it. Supreme Court determines the basic structure. Parliament has no control over it. Parliament has no control over it. Has no control over it. Then India follows constitutional supremacy. India follows constitutional supremacy, unlike parliamentary sovereignty of UK. India follows constitutional supremacy, unlike parliamentary sovereignty of UK. Unlike the parliamentary sovereignty of UK. And then extension of that argument, Supreme Court is considered as the guardian of Constitution. Supreme Court is considered as guardian of Constitution. Hence Parliament cannot dilute basic structure. Or you can use the term, exact word, destroy. Supreme Court cannot destroy basic structure. Supreme Court cannot destroy, hence Parliament cannot destroy basic structure. Then broader way you can say, there are certain criticisms of basic structure like, lack of constitutional basis. There are certain criticisms of basic structure like lack of constitutional basis, subjectivity of the doctrine, lack of constitutional basis, subjectivity of the doctrine, and allegation that it has been misused by the judiciary for its own benefit, and allegation that it has been misused by judiciary for its own benefit. It has been misused by judiciary for its own benefit. For its own benefit. Fine. So then broader conclusion you can say, India has successfully evolved as a robust living democracy. In the last 75 years. Hence, Parliament's limited power Hence, Parliament's limited power has to be continued to maintain the delicate balance between the organs. Parliament's limited power to amend the constitution has to be continued to uphold, to maintain delicate balance between the organs, as well as enable Supreme Court to protect, to guard the constitution, as well as enable Supreme Court to guard the constitution. How to interpret the basic structure? Any words you can bring. Guard the constitution, or you can say because of those words. This is broader way. Of course, here and there you can add an argument, delete an argument, or come up with additional arguments. All those things is absolutely will be there. That is broadly about the basic structure, constitutional morality, amending the constitutional powers, all those things. Fundamental duties, not a single mains question has been asked. If in case they ask also, they have to ask it like what? Remember the very famous, I think in one of the questions that had a reference, I don't know which one, that fundamental duties are integral part of the Indian traditional life. You have to, each and every fundamental duty, you have to say how it has been followed in India's traditional life. No analytical part, nothing. Chances of being asked a question on fundamental duties is very, very less. Even if they ask, you know the basics, you have to link to that. Clear? Enough for us. Again, from current affairs perspective, you don't have anything extra related to this. I have already made you go through that, which is what? Main schedule anyhow we have written. 142 will not write it here. Remember, this was again because of the Delhi Arvind Kejriwal aspects that constitute Supreme Court had mentioned about it. Because of the arrest of the serving chief minister, debates on ethical governance and rule of law. UCC we have done, EWS we have done, hate speech we have done. 142, as I told, I'll take it to judiciary. Ladakh 6th schedule, 6th schedule. Okay, 6th schedule we can do it under federalism also, or because 9th schedule we have done, emergency as I told you. This is federalism one, but we'll do it later. Parliamentary sitting we'll do, 3 language later. Panchayats under local bodies. Then Waqf, that's under bills, urban local bodies, 370. Panchayat development, okay, that is local body again. Federalism, special category, okay. This again, because of the 30 years SR Bomai, special package, demand for new states we have done. Okay, so I think largely this part is done. We'll shift to which one now? Legislature first, because that's more important. Then we'll come back to our executive, all those things. Executive, we don't have too many questions, or maybe what we can do, anyhow we have another for executive, we'll finish. Legislature, we can do it in the afternoon. Okay, I'll show you the executive questions first. Only few questions are there. We'll finish them off. Comparison of constitution, again we'll come back. This is separation, comparison. Where is the executive? Okay, 1 second. I think it's there in the other group of questions. ಯಾಕೆ ಒಂದು ಫೇಲ್ ಆಗ್ತೀನಿ ಕಳ್ಸೋದು?
ಒಂಚೂರು ನೋಡ್ತಿಲ್ಲ ನಮ್ ಕಡೆ. ಹೊಡೆ ಹೊಡಿತಿದೀನಿ, ಗ್ಲಾಸ್ ಹೊಡಿತಿದೀನಿ, ಸೀಲಿಂಗ್ ಹೊಡಿತಾ ಇದೀನಿ.
ನಿನ್ಗೆ ಅನ್ಸುತ್ತಪ್ಪ ನಮ್ಗೆಲ್ಲೋ ಇರುತ್ತೆ, ಇಲ್ಲೆಲ್ಲೋ ಇರ್ತೈತಲೆ. ಆ ಫೈಲ್ಗೆ ಹಾಕ್ಬೇಕು. Akbar? News listen ಮಾಡಲಾ? ಇದು ಯಾರ್ದಿದು? ರಾಜೇಶ್ದಾ? ಹಾಂ ಮಾಡು. 4. Okay, put the heading as executive. Executive means on president and council of ministers, those things. Governor will put it under center-state relations, federalism aspect. So this is one question. There is no larger theme aspect you don't have. This is 1 year. Time limit for president's pardoning power. That is one question. You don't have to write, we'll write the answers then. Then this is another question, 2022. Conditions, essential conditions for exercise of the legislative power by the governor. Very, very simple Lakshmikant question. Discuss the, but this one is a little broader. Legality of the repromulgation of ordinances by governor without placing them before the legislature. Fine, ordinance question. Then 2014, very long back, size of the cabinet should be as big as government can manage, that is government's work justifies, as big as PM can manage. How far the efficacy is inversely related to size of the cabinet. Same question, 2024, why is that parliament? Where is that? I think again they have missed, I don't know where they put. Remember the 2024 question if you recall. Which one? Exactly, cabinet versus parliamentary supremacy. Fine, so 2 questions on cabinet related, 1 question on the president's pardoning power. So first what we'll do this pardoning power question. Because recently Supreme Court gave certain guidelines if you recall related to that. Almost I think, I don't know, maybe some 4-5 months back, December or January, certain guidelines related to what? Death penalty, mercy petitions, because long time mercy petitions were pending. Supreme Court gave certain guidelines that if you recall that there should be a dedicated cell in the Home Ministry or the prison departments, information has to continuously flow, everything should be made online, there should be certain nodal officers. So, and if the Supreme Court has taken the final decision or if the mercy petition has been rejected, within 15 days time gap should be there for the execution, means I mean the death penalty aspect. Within that again if they want judicial representation has to be given, like that few pointers Supreme Court has given, guidelines. For what purpose? To address huge delay in resolution of the mercy petitions by the president or the governor. So in that context, again this issue exactly same. President's delay in commuting death sentences. Short, that means broader article about which one? Article 72, pardoning power of the president, or 161, pardoning power of governor. So that, and of course few first we'll write some basics about which one? This ordinance also, ordinance will again write separately. So because 3 questions will come. I mean if in case they ask, 1 is about the pardoning power of president, 2 is what? Ordinance power of president, and 3 which they have not asked, but of course you should know very basics, your veto power, article 123. Sorry, not article 123, article 111, 123 is your Ordinance power. So those three you have to remember. Other than that, if they ask, they should ask like this. Very simple. When can governor use the legislative powers? Of course, that is also again linked to ordinance only. First, let's write about this. Put the heading broadly, Article 72, President's pardoning power. And we'll write about death penalty also broadly, because you never know, they have not asked a single question on arguments in favor and arguments against death penalty, but you should be knowing about that. Article 72, President's pardoning power. First write the basics, then we'll go to the arguments in favor and against, then we'll come back to the recent current affairs angle. Fine. Article 72, President's pardoning power. If you want the same thing, okay, 161 we'll write separately. Yeah, clarify that. What is it related to? Constitution provides pardoning powers for the president. Constitution provides pardoning power for president with respect to A. Provides pardoning powers to the president with respect to, obviously, which one? Punishment under central law. Sentences under central law. First one is sentences under union law. Sentences under union law. B. If the sentence is a death sentence. If the sentence is a death sentence. If the sentence is a death sentence. And of course, what is the exception? Yeah, so no, not exception, that also. Yeah. If the sentence is by a court martial. See, if the sentence is by court martial, military court. If the sentence is by a court martial. Fine, then types of pardoning power. Types also you can say, tools also you can say, types of pardoning power. Very simple, basics you are writing. Then we'll go to the mains arguments. Obviously, you know, A, pardon. Both conviction and sentence. First one is pardon. Both conviction and sentence forgiven. Both conviction and sentence forgiven. Both sentence and conviction forgiven. B, commutation. Commutation. What will change here? Form of punishment is changed. Means rigorous to simple or death penalty to life imprisonment, like that. Form of punishment is changed. Form of sentence. See, remission. What will change? Exactly. All basics first. You remember, basics also will matter. Duration of the sentence is reduced, but the form of punishment remains the same. Duration of the punishment reduces, but the form of sentence remains the same. Duration of sentence reduces, but the form will remain same. Then respite, special considerations. Respite, special considerations. Means on special considerations, so they will reduce the sentences. Respite, special considerations. Then reprieve, temporary suspension of the punishment. Reprieve, temporary suspension of the punishment. Then link to the governor. Article 161 provides similar powers to the governor with few changes. 161 provides similar power to the governor. Similar power to the governor with few changes. Similar power to the governor with few changes. Similar power to the governor with few changes. Obviously, you know. What is it? First one? Exactly. Governor can pardon any sentence under state law. Governor can pardon any sentence under state law. 2 has no such power with respect to martial courts. Has no such power with respect to martial court. No such power with respect to martial court. C, cannot pardon death sentence. This is constitutional provision, but Supreme Court has told a little, cannot pardon death sentence. Cannot pardon death sentence. However, Supreme Court has clarified that governor can pardon death sentence. Supreme Court has clarified that governor can pardon death sentence. Governor can pardon death sentence. Fine. Then write about the mercy petitions then. Put the subheading there, mercy petitions. Mercy petition. Again, or some people use the term in US as they use what? Clemency. We don't use the term in India, but just to mention that, we use the term clemency petition. Clemency. In US they use this. In India we normally call it as mercy petition. Constitution nowhere mentions the term called as mercy petition, but obviously what is it? Mercy petition means it is a petition filed by the convict to the president or governor. Petition filed by the convict to the president or governor to pardon their sentences. Means pardon means not only pardon or commit anything. Filed by the convict to the president or governor to pardon their sentences. To pardon their sentences. And what you don't have? Constitution has no detailed provisions with respect to it. Means how do you take a decision, all those things. Constitution has no detailed provisions with respect to it. Supreme Court has given the clarity, and then you have to write the cases. Has no detailed provisions with respect to it. Supreme Court has given the clarity. Now, what are those clarities? First one, pardoning power. Supreme Court has given the clarity. Under that, as a guidelines, first one, pardoning power is not discretionary power of the president. Pardoning power is not discretionary power of the president. Of course, that means governor also is not a discretionary power of the president. That means obviously how do you do it? Based on the advice of COM, in bracket Maru Ram case. It is based on the advice of COM, in bracket Maru Ram case. MARU, Maru Ram case. Maru Ram case. Fine, that is one. 2. There should be no inordinate delay, means arbitrary delay. There should be no arbitrary delay in settling the mercy petitions, or what do you call as this, resolving the mercy petitions, dispensing, any words. There should be no arbitrary delay in settling the mercy petitions, in bracket Shatrughan Chauhan case. That is what is this case, this question, Shatrughan Chauhan case. Though what they have not told, Shatrughan Chauhan is, however, specific time limit is not mentioned. Specific time limit is not mentioned. Then resend your prelim statement. Specific time limit is not mentioned. Then pardoning power can be subjected to limited judicial review, again on arbitrary grounds. Pardoning power is subjected to limited judicial review if it is arbitrary. Subjected to limited judicial review if it is arbitrary. In bracket Epuru Sudhakar case. EPURU. Epuru Sudhakar. EPURU. Epuru Sudhakar case. Fine. Then next one, neither the convict, means petitioner, neither the convict nor the family members, neither the convict nor the family members will get an opportunity, neither the convict nor the family members will get an opportunity, to personally meet the president. Means put, put their case forward, to personally meet the president. And then Supreme Court has said that there is no need of detailed guidelines, but recently they have given few guidelines. Supreme Court had said that there is no need of detailed guidelines. There is no need of detailed guidelines for president or for president's pardoning power. There is no need of detailed guidelines for the president's pardoning power. Fine. But recently what they did, that's your extension now, current affairs angle. However, recently, the rarest of rare, everything will put it under arguments favor and against death penalty. Recently, Supreme Court gave certain guidelines. Supreme Court issued certain guidelines to prevent unnecessary delay in mercy petitions. To prevent unnecessary delay in settling the mercy petitions. To prevent unnecessary delays in settling mercy petitions. Not a very, very important current affairs angle, but because it is in news and because again they have touched this topic in your prelims, so we are just mentioning about all these things. First one, A, what they have done. Dedicated cells should be established in home or prison departments, because obviously Home Ministry deals with it, or at the state level, prisons. Dedicated cells should be established in the home or prison department. B, nodal officers should be appointed. Nodal officers should be appointed to coordinate with President or Governor's office. Nodal officers should be appointed to coordinate with President or Governor's office. President or Governor's office. To coordinate with the President or Governor's office. Then entire communication should be done electronically, means avoid the typical documentation works. Entire communication means from home department to governor, from state to president, everything, entire communication should happen electronically to prevent the delays. Communication should happen electronically to prevent the delays. Then 15-day gap between rejection of mercy petition and execution of the convict. 15-day gap between rejection of mercy petition and execution of convict. Then in this 15-day, in this period, convict should be given an opportunity for legal representation as a last chance. In this period, convict should be given an opportunity for legal representation. As a last option. These are broader guidelines. I think few one or two are there, but if you want, you can note them. This is current affairs angle. Now link to that, put the broader heading, death penalty. Under that, arguments favor first and then against. Death penalty, or what you got as capital punishment, any words. Death penalty or capital punishment. Not a theme, but You never know, because in prelims they have asked, and one of the question they had asked about this aspect. Arguments in favor. Obviously, few points you will be knowing. So, generally, try to recall. Why do you think death penalty should continue? Deterrence aspect. Okay, fine. Then, why should it continue, death penalty? That's what, to avoid more crimes means deterrence effect, fear factor. Then, justice to the victims. They are very, very famous arguments. Same things only. Then, proportionality. Okay, please write. So, arguments in favor. First one, doctrine of proportionality. Remember, doctrine of proportionality means what? Your punishment is proportional to the nature of crime that you have committed. Doctrine of proportionality. Sentence, that is, if you want just a single line, doctrine of proportionality. Sentence or punishment should be proportional to the nature of the crime, severity of the crime. Punishment should be proportional to, sentence should be proportional to nature, or you can use the term severity of the crime. Severity of the crime. And obviously what Supreme Court? Supreme Court had said in, there are two cases, but famously Bachchan Singh case. Supreme Court had said in Bachchan Singh case that, where will you only give? Exactly, it should be given in rarest of rare crimes. Supreme Court had said in Bachchan Singh case that it should be given in rarest of rare crimes. It should be given in the rarest of rare crimes. That is one, doctrine of proportionality. B, deterrence effect. Deterrence effect means fear factor. Deterrence effect. Obviously, what do you mean by that? To prevent what do you call this, horrific crimes or horrendous crimes, whatever, heinous crimes in the future. To prevent heinous crimes, H-E-I-N-O-U-S, heinous crimes, horrific crimes in the future. Fear factor in the future. Fine. 3. Justice to the victims and their family. Justice to the victims and their family. Justice to the victims and their family. Obviously what? For example, Ajmal Kasab, 2611. Ajmal Kasab of 2611 deserved death penalty for his inhumane act. Deserved death penalty, or Nirbhaya for that matter, for their inhumane act. Inhumane act. Then chances of misuse is very less. Means why should it continue? Chances of misuse is very less. Obviously why? Because there are multiple hierarchy, that is levels. Chances of misuse is very less because there are multiple opportunities for the convict to question it, to question the sentence. Chances of misuse is very less because there are multiple opportunities for the convict to question death penalty. Imagine right from, if the Sessions Court has given, and then District Court, then you go to High Court, then you go to Supreme Court, then you have what? Review petition, curative petition, and then mercy petitions. So there are multiple opportunities to question death penalty. If you had doubt, in bracket you write review petition, curative petition, mercy petition. Review petition, curative petition, mercy petition. Curative petition, mercy petition. Right? Then next one, what you can say, unnecessary burden on the exchequer. Unnecessary burden on, or tax burden on the exchequer, whatever. Unnecessary burden on the public money can be reduced. Because remember, you may have to put them, keep them there and then keep maintaining them. Unnecessary burden on the public money can be reduced. Can be reduced. Fine. Okay, so these are all arguments that yes, it needs to continue. Now counter arguments. Arguments against. Arguments against. First one, evidence shows that, empirical evidence shows that death penalty has no deterrence effect. Means people will not think about it and then commit the crime. Empirical evidence shows that it has no deterrence effect. It has no deterrence effect. Fine? It has no deterrence. 2. State has no power to take away anybody's life. State has no power to take away an individual's life. So that power is only there for the God, that argument. State has no power to take away any individual's life, anybody's life. Any individual's life. Fine. Then 3. It is an irreversible act. Means let's say if you took a bad decision, it is an irreversible act. What does that mean? Exactly. A person subjected to or a person executed cannot be brought back. It's an irreversible act. A person who is executed cannot be brought back to life. Cannot be brought back to life. Brought back to life. And then globally more than 100 countries have already abolished it. Globally more than 100 countries have already abolished it. More than 100 countries have already abolished it. Then UNGA, UN General Assembly, UNHRC, in the same point, or you can write another point. UNHRC, UNGA have recommended for its complete abolition. UN General Assembly, UN Human Rights Council has recommended for its complete abolition. Recommended for its complete abolition. Then it is based on retributive justice, eye for an eye principle. It is based on retributive, means you did the mistake, you have to suffer for it. It is based on retributive justice, that is eye for an eye principle. Eye for an eye principle. Eye for an eye principle. Then according to Project 39A, means it's a National Law School Delhi group. According to Project 39A, in bracket NLS Delhi, National Project 39A, that is National Law School Delhi, most of the death penalty convicts, death row convicts, according to Project 39A, NLS Delhi, that is, most of the death row convicts belong to religious minorities or SC or ST. More than 80% they have identified. Most of the death row convicts belong to religious minorities or SC or ST. Means probably it indicates that what? They lack legal representation. If you have very good lawyers and all those things, chances of you getting resolve the cases in your favor is very, very high, is the kind of criticisms. A few other arguments are also there. If you want other one, judges are ultimately humans. Judges are ultimately humans, hence judicial errors. Judges are ultimately humans, hence judicial errors are possible. Judicial errors are possible. Former CJIs, former Chief Justices of India, former CJIs have expressed regret. Former CJIs means few former CJIs have expressed regret over their decisions, means involving death penalty. Few former CJIs have expressed their dissatisfaction, that is regret regarding death penalty decisions. I like that multiple ways are there. Then way forward. Way forward. India should shift from retributive towards which one? Reformative, rehabilitative justice. India should shift from retributive to reformative, rehabilitative justice. Reformative, rehabilitative justice. Reformative, rehabilitative justice. 2. Reformative and rehabilitative justice as recommended by Law Commission. As recommended by Law Commission, death penalty should only be given in extreme circumstances related to terrorism, or you can say rarest of rare crimes. It should only be given in extreme cases or extreme circumstances related to terrorism, rarest of rare crimes, etc. Rarest of rare crimes, etc. Then unnecessary delay in inordinate, what they called as unnecessary delays in mercy petition should be avoided. Unnecessary delays in the mercy petition should be avoided. Unnecessary delays in the mercy petition should be avoided. If you want another one, Supreme Court should give detailed guidelines on what constitutes rarest of rare case. In one of few cases they have tried, like Machi Singh case, everything. Supreme Court should give clarity, that is detailed guidelines on what constitutes rarest of rare case or crime. Detailed guidelines on what constitutes rarest of rare crimes. Rarest of rare crimes. Broadly, this is about your President's pardoning power, death penalty if in case they ask. So go through it. Any additional points if you want to, please tell, we can add it. I think broadly we have discussed. So 2 current affairs angle, that's why we mentioned it. Then you have this ordinance question. Ordinance question anytime they can ask. We'll write entire detailed overall details about ordinance. Automatically all this will cover. So put the heading ordinance power. There is no major change between President and Governor here. Ordinance powers. For President, what is the article? Yeah, 123. For Governor, 213. President 123, Governor 213. The entire about ordinances will write automatically this question itself. Maybe if you want, you can write the answer for it then later again. Fine, yeah, write the basic provisions. It is a temporary legislation. It is a temporary legislation issued by the President. We will write over President, automatically you can replace it by Governor. Temporary legislation issued by the President. Issued by the President on the advice of COM. Temporary legislation issued by the President on the advice of COM. B. Obviously, when do you issue? When the legislature is not in session, or of course because Parliament you have a bicameral, when one of those is not in session also is fine, but generally when the legislature is not in session, then it is not a parallel lawmaking power. Means when legislature is functioning you can't issue it. It is not a parallel lawmaking power. Not a parallel lawmaking power. Then maximum time period, maximum what do you call this, validity or maximum lifetime of ordinance is what? 6 months, 6 weeks. These are all very your basic prelims point. Maximum lifetime is 6 months, 6 weeks. 6 months, 6 weeks. Then it is similar to, as this also your prelims question again, it is similar to any act of the Parliament, an ordinary act of the Parliament. It is similar to an ordinary act of Parliament. That means what it can do? Hence it can amend any law, tax, similar to an ordinary act of the Parliament. It can amend any act or tax, amend any law, any act or tax, and what it also has? Yeah, that will write. First you write, it can have retrospective effect. It can have retrospective effect, but cannot amend constitution. It can have a retrospective effect, but cannot amend constitution. In other words, no fundamental rights, nothing. Cannot amend the constitution, including fundamental rights, because that statement was there in your prelims also, and normally we keep telling that. But it cannot amend the constitution, including fundamental rights. Fine. Then not legislature. Government should try to introduce it as a bill. Government should try to introduce it as a bill and mention reasons for promulgating ordinance. Introduce it as a bill and mention the reasons for its promulgation, because that's a keyword they use. Mention reasons for its promulgation. Mention reasons for its promulgation. This is basics. Now, why do you need it? Important. Significance of an ordinance. Significance of an ordinance. Very broader aspects, obviously. Significance of an ordinance. Obviously, why is it needed? Empower the executive. Significance of an ordinance. Empower the Council of Ministers, executive, to deal with. Empower the executive to deal with exigent situations. Means crisis situation, emergency situations, exigent, EXIGENT. Executive to deal with exigent situations. Simple example, during COVID, ordinances related to Epidemics Act, recall that. During COVID, ordinances related to Epidemics Act, Epidemic Diseases Act, Essential Commodities Act was passed. Ordinance related to Epidemic Diseases Act, Essential Commodities Act was passed. Essential Commodities Act was passed. Essential Commodities Act was passed. And that is one. Two, in the recent decades, because of parliamentary disruptions, policy paralysis has increased. Means unable to pass decisions in legislature. Policy paralysis has increased. Hence, ordinance is an option for COM. Policy paralysis has increased. Hence, ordinance is an option for the COM to pass or to introduce whatever, to implement. Ordinance is an opportunity for COM to implement necessary legislations. Fine. The next one, there are adequate checks and balances. To prevent misuse of an ordinance. Then, Parliament does not function throughout the year. Parliament does not function throughout the year. Its average number of its average number of functioning days has reduced to around 70. Its average number of functioning days has reduced to around 70. In bracket ADR, PRS. Remember PRS, that very famous website, ADR, PNS. That means obviously what? Hence, ordinance is a necessary option. Hence, ordinance is a necessary option. Means you don't have a choice at all. Ordinance is a necessary option. Ordinance is a necessary option. Then criticisms. Criticisms. It is legislative power of the executive. It is legislative power of the executive, hence violates. Obviously, legislative power of executive means violates separation of power, Article 50. It is the legislative power of the executive, hence violates separation of power, Article 50. Violates separation of power, Article 50. Article 50. Then 2. Ordinance Raj means too many ordinances. Ordinance Raj bypasses parliamentary scrutiny, compromising collective responsibility. Ordinance Raj bypasses parliamentary scrutiny, thereby compromising collective responsibility. In bracket 75 clause 3. Compromising collective responsibility, Article 75 clause 3. 75 clause 3. If you want simple, for example, Government of NCT Delhi 2023 ordinance. Government of NCT Delhi 2023 ordinance was passed. Right? The next one, what you can say? It provides huge powers to the executive. It provides huge powers to the executive, thereby compromising checks and balances. Thereby compromising checks and balances. Thereby compromising checks and balances. Then in few states, same ordinances have been repromulgated. In few states, same ordinances have been repromulgated. Thereby compromising the power of legislature. Repromulgated, thereby compromising the power of legislature. Compromising the powers of legislature. Now, Supreme Court cases. Actually, we had made a question also on that. Obviously, what are the Supreme Court cases? Yeah, first one, R.C. Cooper case. R.C. Cooper case. Bank nationalization, what they call as ordinance power is subjected to judicial review. Ordinance power is subjected to judicial review. B. Ordinance power is subjected to judicial review. Second one, D.C. Wadhwa case. Repromulgation is constitutional fraud or fraud on the constitution. Exact Supreme Court terms. Repromulgation is violation of constitution also, you can say, is a fraud on the constitution. Then Krishna Kumar case. Ordinance is not an extraordinary power. It should be used in extraordinary circumstance. Ordinance is not an extraordinary power. It should be used in extraordinary circumstance. It should be used in extraordinary circumstance. Fine. Yeah, so broadly these are the ones. If you look at the PYQ also, fine, discuss the legality of repromulgation, or if you look at this question, if you have any extra points, you can note it down. Again, this is a question which has been repeated. I mean, we are expecting multiple times. You can add this point there. Need for or importance of ordinance, whatever you mentioned, you can add this point. In the recent decades, Rajya Sabha is acting as a blocking chamber. Need or significance wherever. Disruptions, I think you mentioned. Legislature, you mentioned. Immediate action, you mentioned. Rajya Sabha acting as a blocking chamber. This means, I think you understand, I don't have to discuss. Rajya Sabha acting as a blocking chamber. Yeah, that point you can add. Then, not necessary. We have discussed all of them. Separation of power you have mentioned. Infringement, separation of power, arbitrary use of power, scrutiny, I think. Okay, broadly you have mentioned, we have mentioned all of them. R.C. Cooper, D.C. Wadhwa, Krishna Kumar. Yeah, fine. I think this is under executive, you have only them. This one, this year's, I think that PYQ is missing. We'll write the answer for that. Where is it? I'll dictate the question. Please note down this year's question. 1 second. Where is that? Parliamentary. The growth of cabinet system. The growth of cabinet system has practically resulted in marginalization of parliamentary supremacy. They use the term elucidate. Growth of cabinet system has practically resulted in marginalization of parliamentary supremacy. Parliamentary supremacy. Fine. It was this 2024 question. Obviously, if you look at it, so what they are telling, because cabinet system means council of ministers or cabinets have become very, very powerful, that means who is weakened? Parliament has weakened is what they are trying to say. Obviously, the question is on what? Cabinet system. First in the introduction, first write about them. That is how you need to structure. India follows parliamentary system. India follows parliamentary system. India follows parliamentary system in which cabinet is considered as what? Nucleus of decision making. Cabinet is considered as the nucleus of decision making. Cabinet is considered as the nucleus of decision making. And just tell briefly what do you mean by that? It consists of the most important COM or the most important ministers, including Prime Minister. It consists of the most important ministers, including PM, including Prime Minister. And obviously what? PM is also what? PM is the, PM is the political head of the cabinet. PM is, this is brief about what do you mean by this cabinet. PM is the political head of the cabinet. Yeah, that is one. I mean, now what you have to refer to, what is the word they have used? Growth of cabinet system. I clarify below. In the recent decades, cabinet has become very powerful. Cabinet has become very powerful. Fine. Now what we can also tell, what is the advantages of that? That also you can tell. Then you can go to which one? Parliamentary supremacy, marginalization. Understood? For that you clarify below significance, or you can say cabinet has become very powerful. It has certain advantages, something like that you can say. Advantages. It has certain advantages. Obviously, what are the advantages? Yeah, first one, quick decision making. Quick decision making. Obviously, why is this? For that you reason, tell the reason. Parliament is a large body, and what is it not? It's not in the session throughout the year. Parliament is a large body and does not function throughout the year. So obviously they can meet and take quick decisions. Does not function throughout the year. Fine. 2. It helps government to respond. It helps government to respond to exigent situations, like how you have ordinance concept. Helps the government to respond to the exigent situations. For example, cabinet announced 20 lakh crore economic stimulus during COVID. For example, cabinet announced 20 lakh crore. Remember Atmanirbhar Bharat concept also broadly that time. 20 lakh crore economic stimulus during COVID. Economic stimulus during COVID. Then 3. As it consists of few members or very few members, accountability is high, because anything goes wrong you can question. As it has very few members, accountability is relatively high. This is advantageous point you have to write. Then, as described by Sir Ivor Jennings. Parliamentary system is prime ministerial system. Sir Ivor Jennings, parliamentary system is prime ministerial system. Parliamentary system is prime ministerial system, and what the cabinet empowers PM. Our cabinet provides an opportunity for PM. Cabinet empowers PM to take significant decisions. Example, Operation Sindoor. Cabinet empowers PM to take very important decisions. Example, recent Operation Sindoor. Obviously, you know that all those meetings, everything happened, they took the very quick decisions. Operation Sindoor decision. Yeah, okay, fine. So then they are the ultimate policy making body, all those things. If you want other one, that one also you can say. Cabinet frames the most important policies and programs. Cabinet frames the most important policies and programs. Example, NEP 2020. NEP 2020, or if you want program, Ayushman Bharat scheme. So everything they will take the call directly. NEP 2020, Ayushman Bharat schemes. Yeah, broadly. Then link to that marginalization. However, huge dominance of cabinet system, huge dominance of cabinet system leads to just using the same words, leads to marginalization of parliamentary supremacy, leads to marginalization of parliamentary supremacy, marginalization of parliamentary supremacy. That is how you need to kind of what substantiate. First one, obviously what it does, it bypasses parliamentary scrutiny. It bypasses parliamentary scrutiny. Bypasses parliamentary scrutiny. Obviously that means what? Thereby compromising, same more or less like how you wrote for ordinance, thereby compromising collective responsibility. The moment you write that, write 75 clause 3. Compromising collective responsibility, that is 75 clause 3. 75 clause 3. Fine. Then next one, the role of opposition. The role of opposition, Rajya Sabha will be demeaned. The role of opposition and Rajya Sabha will be demeaned. If you want link to that, compromising checks and balances. Role of Rajya Sabha and role of opposition and Rajya Sabha will be demeaned, compromising checks and balances. Compromising checks and balances. Checks and balances. Then it concentrates decision making in few ministers, in few people. Concentrates decision making in few people, thereby leading to, or thereby leading to, you can say, concentrates decision making in few people, thereby leading to arbitrary power. Thereby leading to arbitrary power. In bracket, violation of rule of law, Article 14. Violation of rule of law, Article 14. The moment you get arbitrary power, just mention that. Fine. Then next, how we can link cabinet. Powerful cabinet leads to Ordinance Raj. Powerful cabinet leads to Ordinance Raj. Leads to Ordinance Raj. Fine. Obviously, if you ordinance, you can write example. RTI amendment bill, farm bills was passed as ordinances. RTI amendment bill, farm bills were passed as ordinances. Were passed as ordinances. And then in a democracy, Parliament is the ultimate decision maker, not the cabinet. The Parliament should be the ultimate decision maker and not the cabinet. And not the cabinet. Right? Yeah. So then broader conclusion you can say, cabinet is, or cabinet has to be used as a platform. Cabinet should be used as a platform for quick decision making. Should be used as a platform for quick decision making, thereby empowering government to deal with exigent situations. Quick decision making, thereby empowering the government to deal with exigent situations. Empowering government to deal with exigent situation. It should not become a tool. It should not become a tool to bypass the legislature or parliamentary scrutiny. It should not become a tool to bypass parliamentary scrutiny. to bypass the parliamentary scrutiny. Yeah, so broadly, these are the pointers. Of course, you can keep on adding one or two extra points like how this so and so budget aspect also some people tell. Remember, especially when you have a majority party rule, obviously what will happen? Entire Lok Sabha will be dominated by the ruling party. That means indirectly executive. All those you can keep. Anti-defection law is there. Now in parliament also discussions don't happen. So cabinet will become more and more powerful. All those are different ways of referring to the point. As the overall aspect. Then what you have veto power normally, okay. Anyhow, we'll discuss veto power where also your the recent Tamil Nadu governance decision. So there also we'll come back. That we'll discuss under your federalism. I think ordinance is not very important topic. So that's it. You have. Then you have which one as I told? Parliament you have. So let's look at the parliament aspect. Parliament is very favorite topic. Everybody knows that. Let's identify the themes first. You'll be knowing few. Look at it, almost every year you have questions. 22 vice president, 23 presiding officers, as I told you even in the open session itself. 22 they have asked about Rajya Sabha chairperson. 23 they have asked about whom? State legislature chairperson, presiding officer. Then before that long time, this was 2020 Lok Sabha speaker. Then Rajya Sabha question once. MP declining role. If in case you have forgotten, please write the core themes first. Codification, yeah, parliamentary privileges, MPs. So 3 to 4 key pointers are there. I mean themes. Please note down first that this is, of course, like fundamental rights, another very important topic, parliament, and then other important topic, federalism and judiciary. So under parliament, core themes is what? First, favorite topics for UPSC. One is committees. Very favorite theme. One is committees. Second, decline in parliament's effectiveness or role, anything you can call it as. Decline in the effectiveness of parliament. Or broader topic called as, or you can say in bracket, parliamentary reforms. Decline in the effectiveness of parliament, or in bracket, parliamentary reforms. Parliamentary reforms. Then specifically what they are presiding officers. I think now it will not get repeated because it's already been asked multiple times. Presiding officers. Presiding officers, that's another theme. Next one is what? Rajya Sabha. Specifically about Rajya Sabha, they keep asking. Rajya Sabha. Yeah, so this is normal aspects. Now, which is the most, other pending questions, pending topics, or you can say important topics, relevant topics, whatever you can put it as. Of course, so many favorites are there, which is what? First, delimitation, very long pending issue. Delimitation. That is one. Second pending issue, John, Women's Reservation Bill. Women's Reservation Bill. That second pending issue. Third, which one? We discussed something. One nation, one election, we can put it there. Another one was there. Codification, correct. Codification of parliamentary privileges. 1 year they have asked, but because of the last year Supreme Court judgment. Codification of parliamentary privileges. Codification of parliamentary privileges. These are more relevant pending issues. Or you never know, they may go back to the same old issues and ask about parliamentary reform, this, that. That's always there. Fine. So first we'll talk about which one. Presiding officer will not, because we have done it multiple times. First you tell me about this one. So please write the question because again content everything will get repeated here itself. For parliament, the nature of the topic is such a way that if you write answers for PYQ, the content part is automatically done. Then we'll take care of the current affairs issues. Please write this topic, read this question. Try to generate the points. Okay, so I'll discuss about this topic. So whatever brief pointers you note it down, and then you have to write the answers for that. I mean answer for the same question. So obviously what they are trying to say, Rajya Sabha transformed from useless stepney tire, means earlier, I mean what they are trying to say is that it was not so very useful, it was just like another house, that's it. Now what it has become, useful supporting organ. For that they are telling what factors has led to it, what are the areas. Overall, how Rajya Sabha has become a very powerful organ is what they are trying to say. Of course, structuring part what you can do, write briefly about what do you mean by this Rajya Sabha, what is their role, what does it consist of. Fine. Then what do you write? Its transformation into a useful supporting organ. About that you need to write. I will tell the pointers, its transformation. So can you recall how Rajya Sabha has played very important role? What all? When so many are there. First one is, let's say for example, it has protected, means federal equilibrium, means what? Protected the interests of states, equilibrium. Simple example is what? The very famous one, GS-2. Because for GS-2, Rajya Sabha blocked the bill multiple times, 101st constitutional amendment. Understood? Because of that, what happened? They made sure that the interests of the states are protected. Fine. 2. It has acted as what? It has acted as that revisionary chamber or house of elders. First house of elders it has acted as, means what? Making use of the specialists, detailed rational discussions. Specialists, rational discussion. I am briefing it. Same things you need to note down, or what you do, you listen to it, write the answer, then if you have missed out, I will tell those extra points, you can note it down again. Simple example is what? For example, issues related to climate change, surrogacy, data protection, everything, it is actually Rajya Sabha which has discussed in detail, not whom? Not the Lok Sabha. So that's why House of Elders. Then it is also famously called as what? Revisionary chamber. Revisionary chamber or revisionary house. Revisionary chamber, house of dignified debates. I am telling you the keywords, you have to use all of them. It's called as revisionary chamber, house of dignified debates. Look at how it is famously described as dignified debates. So obviously, how do you tell it is a revisionary chamber? For example, it had blocked Pota bill. Pota, because of that only it was what? It was repealed. Then it blocked dowry prohibition bill. Because of that only it went to where? Joint session. Recall, we keep writing that because it acted as the check. It is called as House of Dignified Debates. For that also specifically you can write the number of adjournment motions, the number of questions in question hour, 0 hour is significantly high compared to which house? Exactly, compared to Lok Sabha. But that's why it is called as the very famously House of Dignified Debates. Then it has introduced very important, important significant bills like which one? Rights of Transgenders Bill, Gram Nyayalayas Bill, introduced by Rajya Sabha. So all those are very, lot of what you call as opportunities, or it has what, because using motion of thanks, it tried to act as a check and balance against the government. For example, government was forced to amend President's address, motion of thanks. So it is acting as a checks and balances. Now these are all various ways of telling that yes, it has functioned it has become what? Useful supporting organ. But obviously what you also have to highlight, there are a lot of limitations also. For example, simple ones are what? Lok Sabha has easily tried to bypass it using money bill. With respect to budget, it has no important role there. And so budget, we all know that. So budget is another one. Then it is famously criticized as what? Blocking chamber, which we wrote in your few other question also, means deliberately trying to what? Blocking chamber, block the bills passed by Lok Sabha. Then what it doesn't do, even in Rajya Sabha, few big states dominate. Uttar Pradesh has more seats, Rajya Sabha seats compared to whom? Entire northeast state combinedly. Again few states will dominate. Unlike US, where what they have Senate, equal state, proportional means equal, same number of seats or equal number of seats for all the states, irrespective of population or size. And so like that, the quality of nominated MPs have come down. Relatively now what they largely try to do, celebrities only they try to nominate. Earlier it used to be more of experts, scientists, journalists, that kind of a one. Now it has come down to famous people kind of a one. So that is the quality of the nominated MPs. Then another one is what? The what you call this, it is famously criticized as what? House of fallen horses, means it's a backdoor entry for, it has transformed into a backdoor entry for the defeated politicians. So like that, these are all criticisms. Then few way forwards, like for example, US, as Punchi Commission has told, India should follow US Senate model, or as in House of Lords, they have made an act and tried to make sure that non-party people should be made as members in House of Lords. Or like what they have told, what do you call this, money bill, Supreme Court should come up with guidelines so that they don't try to bypass Rajya Sabha using money bill provision. Like that, few other additional points you have to write. This is a broader picture. Once you try to structure it and write, because or else if I give all the pointers, it will become difficult. I have overall briefed it. Please write the answer. Fine. At least got a broader picture, right? Then again I will sum up. If in case you have missed out, you can note down the points, because writing answers matters a lot. I'll take it as a, how much? 10, 15 marker itself you can write. So please start. Structure it properly. Try to use the keywords. Keywords matter a lot. Don't try to put frameworks, write it as a typical answer, like how you write in mains. Don't consider it as, okay, I'll just put pointers, I'll go and write in the direct exam. Doesn't work like that. Okay, so see which points you have mentioned, you have not mentioned. I'll just broadly sum up. If in case you have missed out, keep noting it down. Fine, and the significant introduction part, as I told you, what you have to write briefly about. Write about Rajya Sabha, that Rajya Sabha, India follows a bicameral system in our bicameral parliament in which Rajya Sabha or Council of States is for what? He has to represent, okay, you can write it as an answer if you want again. If in case you have missed out, you can note it down. So I will just tell you the broader structure part. So please start. India follows bicameral legislature consisting of Lok Sabha and Rajya Sabha. India, and you compare with your answer, you will get a broader understanding that where do you stand, what are the challenges. India follows a bicameral legislature consisting of Lok Sabha and Rajya Sabha. Lok Sabha and Rajya Sabha. Rajya Sabha is considered to represent the interests of states as well as union territories. Or Rajya Sabha is considered to represent the interests of states as well as union territories. Represent the interests of states as well as union territories. Then below, in the post-independence era, Rajya Sabha has undergone a transformation from being criticized as what? Use those keywords in the question. From being criticized as a useless stepney tire. Exact words we are trying to use to connect to the evaluator. From being criticized as a useless stepney tire to its evolution as the most useful supporting organ. From being criticized as a useless step-knitter to its evolution as the most useful supportive organ or supporting organ. Most useful supporting organ. Fine? Yeah, under that write those points. First one, it has helped in achieving federal equilibrium. Helped in achieving federal equilibrium. Keep underlining the keywords. Helped in achieving federal equilibrium. If you have written those points, it's fine, or else add it. Helped in achieving federal equilibrium. Fine? Simple. That means what? Thereby protecting interests of states. Thereby protecting interests of states. Simple example. The best example is what? Yeah. GST, that is 101st GST, or you can say 101st Amendment Bill was refined by Rajya Sabha. GST, that is 101st Constitutional Amendment Bill, was refined by Rajya Sabha. That is one. Fine. Two. Second one, it is, or it has evolved as the, it is evolved into whatever as the House of Dignified Debates. House of Dignified Debates. House of Dignified Debates. Tell what does that mean? Significant issues related to climate change, surrogacy, data protection were discussed in detail by Rajya Sabha. Significant issues related to climate change, surrogacy, data protection discussed in detail by Rajya Sabha. Discussed in detail by Rajya Sabha. 3. It has acted as revisionary chamber. It has acted as revisionary chamber. Acted as a revisionary chamber. What do you mean by that? It has blocked, or it has checked, better word, it has checked hasty legislations or hasty bills passed by Lok Sabha. It has checked hasty bills passed by Lok Sabha. Hasty bills passed by Lok Sabha. Simple example, which one? I have told you that, yeah, Pota bill blocked by Rajya Sabha, which leads to its repeal. Pota bill was blocked by Rajya Sabha later, or which led to its repeal. If you want other, dowry prohibition blocked by Rajya Sabha, which led to joint sitting. Pota bill blocked by Rajya Sabha, which leads to its repeal. Dowry prohibition bill was passed by it, was blocked by it, which led to joint sitting. Which led to the joint sitting. And then next one, it has introduced significant bills like, it has introduced significant bills like, as I told, which one? Rights of Transgenders Bill, Gram Nyayalayas Bill, Rights of Transgenders Bill, Gram Nyayalayas Bill, Gram Nyayalayas Bill. Then it is famously described as House of Elders. It is famously described as House of Elders. Continue the same point. House of Elders. It consists of experts as nominated members. Consists of experts as nominated members. Consists of experts as nominated members, thereby participating in rational objective discussion. Experts as nominated members, thereby participating in rational objective discussion. Participating in rational objective discussion. Then compared to Lok Sabha, compared to Lok Sabha. Rajya Sabha functions for more number of days. Rajya Sabha functions for more number of days. More number of days and yeah, adjournment motion, question hour, 0 hour are more effective. Adjournment motions, question hour, 0 hour are more effective. Question hour, 0 hour are more effective. Yeah, now, however, Rajya Sabha still suffers from various limitations, which Rajya Sabha still suffers from various limitations, which dilutes its effectiveness. Which dilutes its effectiveness. Dilutes its effectiveness. Fine, like first one under that, obviously what? Money bill has been used as a provision, as a tool, you can say. Money bill has been used as a tool to bypass Rajya Sabha. Example, you know, please write that. Money bill used as a provision to bypass Rajya Sabha. Example, Aadhaar bill controversy or Aadhaar bill. Aadhaar bill 2016. Aadhaar bill 2016. Then 2. It has very limited role to play in. It has very limited role to play in discussion or passing of budget. Very limited role to play in the discussion or passing of budget. Discussion or passing of the budget. Fine. Then next one, it is criticized as a blocking chamber. Criticized as blocking chamber. Again, the name itself says that is criticized as a blocking chamber. That is, the name is, you can write that one sentence, that is deliberately blocking the bills passed by Lok Sabha. Deliberately blocking bills passed by Lok Sabha. Blocking the bills passed by Lok Sabha. Fine. Then next one, criticized as backdoor entry of the defeated politicians. More harsher word is what? Foreign nurses, but some people, I mean, if you don't want to write that, backdoor entry of defeated politicians, thereby going against people's mandate. Backdoor entry of the defeated politicians, thereby going against people's mandate. Thereby going against people's mandate. Going against people's mandate. Fine. Then, similar to Lok Sabha, Rajya Sabha is also dominated by few big states. Similar to Lok Sabha, Rajya Sabha is also dominated by few big states. Substantiate that. 5 big states. Example, UP has 31 seats, which is more than all the 8 northeast states combined. UP has 31 seats, which is more than all the 8 northeast states combined. All the 8 northeast states combined. Then the quality of nominated MPs has decreased drastically. Quality of nominated MPs has decreased drastically. Quality of nominated MPs has decreased drastically. Earlier, it used to consist of journalists, scientists, social activists, and now celebrities. Earlier, it consisted of journalists, activists, scientists, and now celebrities. You don't have to name, but that is broadly the points. The loopholes. Now, way forward. Punchi Commission. Rajya Sabha should follow Senate model. Punchi Commission. So these points, any question on Rajya Sabha, you can make use of that. That's why I am making it as broad as possible. Punchi Commission, Rajya Sabha should follow Senate model. So Senate model means equal number of all states, equal number of seats for all states, equal number of seats for all the states. Follow Senate model. B, follow UK practice, UK model. Follow UK model in which House of Lords consists of, UK model in which House of Lords consists of non-political, non-partisan people, members. House of Lords consists of non-political, non-partisan people or members, whatever. Non-political, non-partisan members. Non-political, non-partisan members. Then Supreme Court should issue detailed guidelines. Supreme Court should issue detailed guidelines to avoid misuse of money bill to bypass Rajya Sabha. Misuse of money bill to bypass Rajya Sabha. To bypass Rajya Sabha. Yeah, okay. So these are broadly the pointers related to Rajya Sabha. You compare your answer and then try to yeah, that also you can say. That means when there was a majority party rule, obviously that time, actually that statement was given by Jawaharlal Nehru in 1950, saying that Rajya Sabha unfortunately has become a useless stepney tire, because Lok Sabha obviously entirely was dominated by Congress era. So where is the debates? Automatically pass it and then easily get it, what do you call it, or sometimes bypass it also. That's why it is called. Yeah, you can write that. If you have few pointers, that also you can write. Because this itself you have so many, it's fine. Or one or two lines or something like a paragraph, you can talk about that, of course, anytime. Yeah, so any question on Rajya Sabha, you can use these examples. You may get few other points also, you can go and note it down. Every time it will be useful. Fine, same aspect like how I told, speaker they ask, vice president they ask, assembly speaker they ask. Same point, Rajya Sabha they ask. And then not exactly same, but you can identify that. Good, because 1 year they ask Rajya Sabha means another year they'll ask about. This is more direct, I mean, except few points. So look at the demand. Other things we'll discuss in the afternoon, I mean evening session. So just trying to identify Rajya Sabha, Council, Speaker, Vice President, like that. Those are the themes. Right? Yeah, we'll write it in the evening one. I think they had mentioned it as 5 to 8:30, right? 4 to 7:30 they have clarified. Okay. 4:30 they have mentioned. Okay. I told them to make it 4 to 7:30 because Rakesh will not cooperate with us. You know the reason today. So 7:30 you have the, so nobody will cooperate for, you can't stretch beyond 7:30 today. Probably I'll just make sure once. I think it will be 4 to 7:30. Maybe, probably, I don't know if class may be occupied. That's why it might be. Fine, I'll announce it in the portal, or else it will remain the same. We'll meet again in the, and we'll try to complete Parliament as much as possible because it's a very detailed chapter. Then we'll go to your elections RP Act.